Hello and a warm welcome to Well This Week by latestlaws.com. This is a weekly program, so hit the bell icon to get notifications for new videos. My name is Sheetal Joon, Associate Editor, latestlaws.com, and I will be taking you through the significant orders and judgments passed by various courts in the country and some important international news from this week. Let's begin with Supreme Court this week. Terminating the employment of a woman on the ground that she has got married is a coarse case of gender discrimination and inequality, the Supreme Court remarked, as it directed the centre to pay a compensation of Rs 60 lakh to a former military nurse who was removed from services under a now defunct army order that provided marriage as a ground for such action. A bench of Justice Sanjeev Khanna and Justice Dipankar Datta's directive came while hearing a case in which a permanent commissioned officer, former Lieutenant Selina Johns of Military Nursing Services (MNS), was removed from service by the Army in August 1988. The release order said her job was terminated on the ground that she got married in April that year and she had obtained a low grade in the Annual Confidential Report (ACR). Acceptance of such patriarchal rule undermines the human dignity, right to non-discrimination and fair treatment, the court said. The Supreme Court, while allowing an appeal seeking the quashing of an FIR, remarked that it has time and again pointed out the clear distinction between a civil wrong in the form of breach of contract, non-payment of money, or disregard to or violation of the contractual terms and a criminal offence under Section 420 and 406 of the IPC. A division bench of Justice Sanjeev Khanna and Justice Dipankar Datta observed that initiating the criminal process for oblique purposes is bad in law and amounts to abuse of process of law. The court stated that the various judgments addressing this point are somehow overlooked and are not being applied and enforced. It is one thing to say that a case has been made out for trial and criminal proceedings should not be quashed, but another thing to say that a person must undergo a criminal trial despite the fact that no offence has been made out in the complaint, the court said. Ensuring a free and fair electoral process is imperative for maintaining people's trust in representative democracy, the Supreme Court has said. The court had declared a defeated AAP Congress Alliance candidate Kuldeep Kumar the mayor of Chandigarh after overturning the result of the controversial civic poll where the BJP nominee had emerged as an unlikely winner amid allegations of rigging of the counting process by the returning officer. In its judgment, a bench headed by CJ Adiva Chandrachud noted that the top court has consistently held that fair and free elections are a part of the basic structure of the constitution. It said elections at the local participatory level act as a microcosm of the larger democratic structure in the country, and local governments such as municipal corporations engage with issues that affect citizens' daily lives and act as a primary point of contact with representative democracy. A crucial amendment to the surrogacy rules allowing married couples to use an egg or sperm of a donor in case a partner is suffering from a medical condition comes after the Supreme Court asked why the centre was not taking a decision on the matter. The Union Health Ministry amended the earlier rules that stated that couples undergoing surrogacy must have both gametes from the intending couple. The very purpose of surrogacy would get defeated by such rules, an apex court bench had observed in December last year, while permitting more than 24 petitioners to use the donor eggs to become mothers through surrogacy. In January, the Supreme Court had asked the centre why it was not taking a decision despite many women rushing to the top court with grievance. The centre, represented by Additional Solicitor General Aishwarya Bhatti, has said that last month that the government was reconsidering the amendment brought in surrogacy law last year. Now let's have an overview of High Courts. The single judge bench of the Jharkhand High Court has held that criminal courts are not meant to be used for settling scores or pressurize the parties to settle the dispute. Whenever ingredients of criminal offences are made out, criminal courts can take cognizance and the court quashes the criminal case arising out of a breach of the agreement. It was furthermore observed that unless the fraudulent and dishonest intention was there from the start of the transaction, breach of contract does not give rise to a criminal prosecution for cheating. Merely on the allegations of failure to keep promises will not be enough to initiate criminal proceeding. The single judge bench of the Andhra Pradesh High Court has held that merely because the petitioners were able to abscond till the completion of the investigation and filing of the charge sheet cannot be ground for allowing a second anticipatory bail application. The court observed that it cannot be justified to grant anticipatory bail just because the petitioners cannot be apprehended before the investigation is concluded. It was furthermore observed that it is not the case of the petitioner. They are eligible for anticipatory bail because they cooperated with the investigation. After their request for anticipatory bail was denied, the petitioners did not provide any documentation indicating that they complied with the investigating officer. The Allahabad High Court, in a petition challenging reassessment proceedings under Section 148 of the Income Tax Act, observed that the assessing authorities are only required to record bona fide satisfaction regarding escapement of income for assuming jurisdiction, and it is not necessary for the assessing authorities to record reasons to believe. The court noted that under the amended law, it is no longer the obligation of the assessing authority to record a reason to believe before assuming jurisdiction to reassess an assessee, and a bona fide satisfaction reached as to escapement of income and made suffice the test of the valid assumption of jurisdiction. The single judge bench of the Jharkhand High Court has held that any one single circumstance cannot be treated as of universal validity or as necessarily justifying the grant or refusal of bail. The High Court and Court of Session, to whom the application for anticipatory bail is made out, are to be left free in the exercise of their judicial discretion to grant bail if they consider it fit to do so on the particular facts and circumstances of the case and on such conditions as the case may warrant. It was furthermore observed that many factors must be taken into consideration when determining whether or not to grant bail, and the totality of these factors must be considered before reaching a decision. The grant or denial of bail cannot be justified by a single circumstance as having universal validity. The single judge bench of the Tripura High Court has held that discovery of documents can be objected to on the grounds of legal or professional privilege, that they may tend to criminate a party or expose him to forfeiture, that they are protected by public policy, that they are not in the sole possession of the party, that they solely relate to the case of the party, that they are in the position of the party as an agent or a representative of another, and that they disclose evidence of party's own case. The court observed that Order 11 deals with the production of documents and the answering of questions in the form of affidavit in relation to discovery and inspection through interrogatories. These provisions aimed to expedite the case during the initial stage before the trial, whereas the subsequent rules of evidence are designed to uncover the truth during the trial phase or give evidence. Moving on to international news this week. The Alabama Supreme Court of the United States has ruled that frozen embryos created through in vitro fertilization (IVF) are to be legally considered as children under state law. The decision holds significant consequences, asserting that such embryos fall under legislation dealing with the wrongful death of a minor if destroyed. The court's opinion, a first of its kind, declared that the Wrongful Death of a Minor Act applies to all the unborn children regardless of their location, including those located outside of a biological uterus at the time they are killed. WikiLeaks founder Julian Assange should face espionage charges in the United States because he put innocent lives at risk, went beyond journalism in his bid to solicit, steal, and indiscriminately publish classified US government documents, lawyers of the American government argued on Wednesday. The lawyers spoke before the Britain's High Court in response to a last-ditch bid by Assange's defense to stop his extradition from the United Kingdom to the US. Assange's lawyers are asking the High Court to grant him a new appeal, his last roll of the legal dice in the saga that has kept him in the British high security prison for the last 5 years. The judge overseeing the case reserved the decision at the end of the 2-day hearing, and a ruling on Assange's future is expected until March at the earliest. In the end, we have miscellaneous news. Pushing for objectivity and accountability in the criminal justice system to prevent needless arrests, the Supreme Court has directed the Union government to inform it whether a new law to facilitate the grant of bail is in works. A bench of Justice M. Sundaresh and Justice S.V.N. Bhatti referred to its July 2022 judgment, in which it had called upon the centre to consider framing a new law on bail of warding off unnecessary arrests, especially in case where the maximum punishment under the alleged offence is up to 7 years in jail. In its July 2022 judgment, the top court emphasized that India should never become a police state where investigating agencies act like vestiges of the colonial era, issuing a slew of directions for the investigating agencies and the subordinate courts on the arrest and grant of bail. The Bar Council of India has extended its profound appreciation for groundbreaking initiatives spearheaded by Centre in bolstering the criminal justice system of India. Calling the introduction of the 3 new criminal laws as ushering in a new era, the BCI has stressed that this legislative milestone marks a pivotal juncture in the evolution of India's criminal justice apparatus, heralding a paradigm shift towards a system characterized by affordability, accessibility, and citizen centricity. Thank you for watching and have a nice day. This is a weekly program, and to get more information, please check the description box, and for weekly updates, like and subscribe to our channel.